Hi, this is Bennett Kelly with the Internet Law Center, and this is your audio executive summary of the cyber report that we sent out by email today, and it is a special America's Cup edition. Today, August 22nd, is the 165th anniversary of the schooner America seizing the cup and bringing it back from Great Britain, and it is held at most of those years, and currently the holder is Team Oracle, which will be defending the cup in 2017 in San Francisco. But moving along, we have this edition of Cyber Report has updates in 10 areas, and we're going to zip through them, starting with our lead story. Update number 1, President Obama signing the Defend Trade Secret Act, and it's an important development because it creates a federal remedy for trade secrets and expands the statute of limitations for 5 years, allows for treble damages, and also allows a special ex parte remedy where you can seize the trade secrets prior to giving notice of the lawsuit. So it's a unique remedy. And in addition, there's an important point that you need to be aware of, in that it provides protection to whistleblowers who report trade secret violations and requires employers to give notice to employees of this immunity provision in any proprietary agreement entered after the effective date of this law. And so going forward, if you want protection under this act, you need to update your proprietary agreement, and we're happy to help you with that. Our next update is in the area of privacy. There's been a lot of conflict with the U.S. and the EU, particularly after the Snowden revelations, and which led to a court invalidating, the European Court of Justice invalidating the existing U.S.-EU Safe Harbor program. After much negotiation, it has been replaced with a new U.S.-EU Privacy Shield, which went into effect on August 1. Details are available on our site and as well as in the newsletter. In addition, you can listen to a discussion I had with former Commerce Secretary Cameron Carey on the whole U.S.-EU conflict, and there's a link to that. In Mobi, one of the largest mobile ad networks, has gotten tagged by the FTC for tracking geo-tracking consumers, despite saying that it was not. Obviously never a good thing for with the FTC, and they had a nice consent decree and a $4 million civil penalty. One interesting development in the courts is in the Sixth Circuit, the question of software used to monitor, some often surreptitiously monitor, for example, children or spouse, is a growing market, and whether or not there's liability for the individual person who installs it is one thing, but the Sixth Circuit actually held that the use of the software itself, violates the Wiretap Act, and that it is an illegal recording device. So that and it's definitely going to cause some issues for that industry. Quick update, the FTC in 2014 had a big workshop on big data and expressed concerns about how it could be potentially misused, and so they've now issued a report on that conference. And just in past practice, when the FTC starts exploring an issue, then does a report, it then often looks for areas of potential enforcement action. So basically, the FTC is trying to communicate to us that is a priority, so be on the lookout. Now we move to topic 3, in terms of service. And 2 recent court cases illustrate 2 important things. You need to revisit your terms of service. One, if it's important, if there's any terms in there that are important and you want to make sure they are enforceable, make sure you get clear consumer consent. The second thing that's coming out is if you're a content provider and you're worried about scraping, there's a Facebook case now that says that if you are a content provider or you're a website and you have clear terms and conditions that say do not use our content, and then you become aware that someone is engaged in that content, you provide them notice and take technological measures to try to block that person from accessing the content, and they do it nonetheless, that in itself can be a violation of the Computer Fraud and Abuse Act. and which has civil and criminal remedies. And so it's important clarification from the courts, which have been reluctant to to automatically translate a violation of the terms and conditions to a criminal liability. Update area number 4, advertising law. There's a big hullabaloo over increased use of ad blocking. It's now deemed to cost the advertising industry $22 billion. And that's no small change. We actually had a segment on the growth of ad blocking with Paige Fair not too long ago, so there's a link to that show. We encourage you to check it out. But on the FTC has recently been getting very serious about native advertising, and it's an illustration of their consent decree with Lord and Taylor. They really cracked down. They paid for placement in a magazine and didn't disclose it, and then at the same time they violated the endorsement guidelines by encouraging models to all wear the same dress and publish pictures of them on Instagram without disclosing that they were paid sponsors. And that got them a nice reward from the FTC. And Warner Brothers also made a similar mistake with their game Mordor, Shadow of Mordor video game. So 1-800-CONTACTS has been very aggressive in terms of trying to combat competitive keyword search advertising. At one point, they got the state of Utah to pass some law that tried to make it a trademark violation, but ultimately they threatened litigation, and most of their competitors agreed to settlements with them that would prevent them from doing that. And the FTC has now stepped in and said, sorry guys, but that's restraining competition. And so there's now an antitrust complaint being filed by the FTC against 1-800-CONTACTS, and we will see how that plays out. Moving on to our next topic, cyber harassment. And there's a major development here. Jackie Spear, congressman from California, has introduced legislation at the federal level for civil and criminal remedies for revenge porn, and it's the Intimate Privacy Protection Act. And while there are a number of states that do have it, there's 34 states so far, this would be a significant development. There was one step back in Rhode Island. The state's first female governor, Gina Raimondo, actually vetoed legislation. She became the first governor to veto revenge porn legislation. But hopefully they'll straighten that out in the next session. Big development in terms of whether the extent to which Section 230, which immunizes websites by saying that if you provide a forum for comments, you're not liable for their content. So whatever I post on Facebook, Facebook's not liable for that. And there was a case involving the model forum called Model Mayhem. Models post their pictures and photographers are there. It's a way for them to meet each other and try to develop business. One model sued Model Mayhem because it turns out there was a team of members who were trolls and were actually raping models, and the site knew about it. And the court said, well, that is different. That's not related to their statements on the web. That's conduct that the website was aware of, and so therefore the immunity does not protect them here, and the lawsuit can proceed. And the issue with social media, there's a significant development. We're all familiar with the movie Finding Nemo. Well, this is a case of Finding Nemo, a Texas pet store and services company that was babysitting a fish, and I don't know how you screw that up, but they managed to. And they got a 1-star review, and because their terms and conditions prohibited negative reviews, they actually sued the company, the consumer, which was a big mistake because that immediately got press, and they became nationally famous. And more importantly, Yelp made them one of the early recipients of their new label that has a consumer alert, questionable legal threats, and they post that on Yelp. Companies that threaten to sue their consumers who give reviews, and so there's definitely a disincentive there. There's also federal legislation pending that will prohibit terms and conditions that penalize consumer reviews, and I would suspect there's a good chance that could pass by the end of the year. On the other area, there's been a slew of lawsuits against Facebook and Twitter and the like over their use of their services by ISIS and Hamas and others. There's a view that this is aiding and comforting the enemy, but again, it comes up to Section 230's immunity. So far, the first of these wave of suits has lost, and what the court has found that clearly this is covered by the immunity under Section 230. They're not liable for statements of ISIS on Twitter. But other cases trigger are based on both U.S. and Israeli law, so we'll see how that plays out. Next update, cybersecurity. And there's an alarming rise in ransomware, and you definitely want to look into that. Make sure that you have a plan in place in the event of a breach. And we have a link to a segment we did on Cyber Law Business Report on ransomware, but make sure you're up to date on that. The FTC has had two cases in where they sought consent decrees for lack of adequate security, and only two cases have they been challenged. One was recently the Wyndham case, where they were successful, and ultimately Wyndham settled after losing on appeal. And LabMD fought the FTC and even got an early victory where the administrative law judge says it wasn't a clear consumer injury, but the FTC reviewed it further and said, sorry, no. Anytime you have sensitive medical data that is exposed on the web, that is significant consumer injury, even if no identifiable case of it occurs. So clearly the FTC is sending a strong signal there. Last three areas. One is probably read about the transition of the management of certain functions of the domain name system, the IANA functions. That's being transitioned to ICANN at the end of September. There may be a possibility of a legislative or a legal challenge to that, but that seems to be proceeding. The last of the Amazon tax cases has finally been decided. The 10th Circuit has upheld Colorado's law that required online retailers to disclose, out-of-state retailers to actually make certain disclosures to consumers that they have an obligation to pay taxes and to remit information to the state of Colorado, which I thought clearly had a disproportionate impact on interstate commerce, but it was upheld by the appeals court on bank. And the last is there's an update by the Department of Labor as to the overtime rules, and significantly changing the threshold amount for when overtime will be required. And there's information in the newsletter about that, as well as a link. But the more important point to highlight here is that whatever state you're in, those states are always updating the requirements and disclosure requirements for employers in that state. And so it's important that as part of your year-end planning that you have and take into account what are these changes, and so that you're prepared going forward for the new year. If you don't have an employment lawyer, we don't focus on that. We do some, but we're happy to set you up with someone who you may find that you can work with. But that is all we have for our update. This is the executive summary. I also encourage you to listen to Cyber Law and Business Report, where we cover a lot of these issues on a weekly basis. It airs every Wednesday at 10 a.m. Pacific on Cranberry Radio, our new home, and we also can download it from most podcast channels, or you can find it on our blog at cyberlawradio.wordpress.com. And in addition, this week we actually have a very interesting show. We have Dan Lyons, who is the author of Disrupted and one of the contributing screenwriters to the hit HBO show Silicon Valley. So I hope you listen to it, and I hope you enjoyed this inaugural audio executive summary of Cyber Report. Hope you enjoyed the report, which you should receive by email. If you didn't get the email and you want to sign up, just go to our website, internetlawcenter.net, and you can sign up there. Until then, this is Ben and Kelly. Have a great week. Cyber Report and this audio executive summary are publications of the Internet Law Center. They are for informational purposes only and do not constitute legal advice.